The anti-drug campaign is one of the priority initiatives of the Duterte administration, and President Duterte has received both praise and criticism for it. The alleged extrajudicial killings have been by far the most controversial aspect of it. In connection to this, the Quezon City Police District is studying the possibility of reviving its house-to-house drug testing program. So tonight we ask our debaters whether or not the house-to-house drug testing by the PNP is constitutional in the first place. Hello, I'm Maiki Oreta, and you're watching Square Off Season 15, The Firm Debates.
The Quezon City Police District is studying the possibility of reviving its house-to-house drug testing program following a court ruling that dismissed a petition against it. The initiative was implemented in barangays South Triangle and Payatas A last year.
Ito po ay hindi mandatory. Ito po ay on voluntary basis na part ng kanilang house visitation ay kanilang hinihimok yung mga naninirahan doon na mag-undergo ng libreng drug test. At itong drug test kit naman po ito ay provide o sponsored po ito ng barangay. Kasama ang kapulisan at mga purok leaders.
Some residents cried foul over the practice for being anti-poor, even comparing it to harassment and public shaming. But the police say everything is above board and voluntary.
Kung sila po ay mag-undergo naman test at nag-prove na positive, then ang susunod po doon ay tatanungin sila kung sila ay papayag na pumasok doon sa ating programa ng rehabilitation kung saan magsasagawa ng drug dependency evaluation, and from there malalaman po kung kinakailangan silang dalhin sa inpatient rehabilitation center.
Newly installed NCRPO Chief Director Camilo Cascolan for his part says while they support the anti-drug campaign, there should be supplemental guidelines in the implementation of the initiative. So, is the PNP's conduct of house-to-house drug testing unconstitutional?
Arguing for the affirmative side is St. Louis University. All the way from the summer capital of the Philippines, Baguio City, the contenders from St. Louis University.
My teammates are very, very intellectual. They have a lot of ideas as far as different subject matters of debates are concerned. They're very passionate as well, and they're very easy to work with. Our team strategy is just mainly to bring up as many ideas as we can, and of all those ideas, we try to point out which ones are strong ones, which we used as our basis of arguments for this debate.
My teammates are both funny and at the same time can be serious whenever the situation calls for it. The first thing we always do is to let all arguments come out. It doesn't matter whether that's pro or against the motion. I mean, without respect to the side we are defending, for as long as we get to gather all the ideas and later on we sort them according to priority, relevance.
We have to be a single entity, not working as three individuals. They are very passionate with regard to debate. They actually make sure that everything is prepared, everything is rehearsed, in order to make sure that we give our opponents a good game.
Team St. Louis University. Ethical, determined, talented. And taking on the negative side is CorJesu College. All the way from the gate city of the South, Digos, Davao del Sur, the next generation lawyers from CorJesu College.
When it comes to debate, my teammates and I tend to work hard in order to learn about the issues. Our team strategy to win the match is to read and to understand the issue better in order to present more critical and a more solid stand.
My teammates are very diligent and they accept constructive criticism very well and use them to improve their skills in debating. The team's strategy is just to come very prepared.
I have learned a lot of things from them. It's preparation and prayer. I believe we're gonna win this thing because we have this kind of teamwork that I think other teams don't have.
Team CorJesu College, dedicated, passionate, determined. Let's now meet our distinguished judges. First off, we have attorney Raquel Wealth Tagian, a partner at the VNA law firm. Next, we have attorney Bernard Benjamin Aniag. He is a managing partner at the Akende Yebra Aniag Loon and Associates. And presiding as our chief adjudicator is Judge Marie Claire Victoria Mabuta Sordan from the Regional Trial Court Branch 97 in Antipolo City. We're using a modified Oregon Oxford format. The debate is between two sides, the affirmative and the negative, with 3 members each. Each debater from the affirmative side argues the necessity, beneficiality, and practicability of the proposition, while the counterpart debaters on the negative side oppose these arguments. Each debater is given 4 minutes to deliver a constructive speech and rebut the previous argument. Each debater is given 2 minutes to interpolate or cross-examine the opposing debater. Only categorical questions may be asked. Each of the judges may ask 1 question of each speaker within that speaker's time limit. The judges score each team in terms of manner, matter, and interpolation. The team with a higher score from each judge gets a point. The team with the most number of points wins the debate. The chief adjudicator rules in the event of ties, objections, or contestations. This week's proposition: let it be resolved that the Philippine National Police's conduct of house-to-house drug testing is unconstitutional. First up, for the affirmative side, we have Mico. Mico, you've got 4 minutes to tell us why the PNP's house-to-house drug testing must be deemed as unconstitutional.
The rights of every man are diminished when the rights of one man are threatened. John F. Kennedy. Your Honors, worthy opponents, ladies and gentlemen, good evening. We from St. Louis University humbly submit that the PNP's conduct of house-to-house drug testing is unconstitutional. This is what happens. The police would knock on every household to conduct an alleged voluntary and random drug test, whereby the police would do the test right there and there. The police is also the examining officer in this particular program. One of the barangays tested last year was Barangay Payatas, and Barangay Captain Juliet Peña of the said barangay was interviewed by DZMM and Rappler, and she stated that she assigned village leaders to conduct a survey and they would create a list of possible drug users. Incidentally, the list forwarded is the same list that the police follows to determine which household will be knocked. Thus, there is already a predetermined target which defeats the hallmark of a valid drug test, which must be random and suspicionless. This debate will dwell on the unconstitutionality of the said conduct, whether such is consented or not consented. 2 points, Your Honors. First, there is an arbitrary exercise of police power. Second, there is a violation of the Equal Protection Clause. First point, while we acknowledge that the police power is considered the least pervasive, the most pervasive, the least limitable, and the most demanding inherent power of the state, such power is not absolute. Police power is lodged primarily in the legislature. It is only exercised by the executive department by virtue of a valid delegation. The police cannot go beyond the power granted to them by Congress. In the case of Fabie versus City of Manila, the Supreme Court ruled that in order to validly exercise police power, there must be a lawful subject and a lawful means. In this case, we do not have lawful means. In constitutional law, the end does not justify the means. A policy, no matter how noble, must be pursued by a lawful method. There is no lawful method in this case because the standards under the Republic Act 9165 were not complied with. The provisions in a department order cannot amend the provisions of a legislative act. It is basic under statutory construction that a legislative act is preferred over a mere department order. Last point, Your Honors, it violates the Equal Protection Clause. The house-to-house drug testing is not random and suspicionless as required in the case of Social Justice Society versus Dangerous Drugs Board and PIDEA. The subjects of the drug test are already predetermined since they were forwarded by the barangay officials based solely on surveys and drop boxes. It is not suspicionless since persons subjected to drug tests are either drug users who voluntarily surrender before the barangay with a promise that they will stop drug use, or civilians who were called by the police by reason of the narco list, a list which even includes dead or inexistent persons, a list of suspected drug users by reason of either their past record of drug use or unverified reports. Furthermore, the conduct was made in slum areas or poor communities, which creates invalid classification since the rich and the poor are not precluded from possibly being involved in a drug case. Your Honors, we are all for the prevention of drug abuse, but along with such prevention are the constitutionally granted rights that our police, the very officers who took an oath to uphold the Constitution, cannot abuse. Thank you.
2 minutes for the cross-examination.
Good evening, Counsel.
Hi, Kim.
When we say something is unconstitutional, either it violates a provision of the Constitution or it finds
Yes,
no
like the
basis in the
Equal Protection
Constitution.
Clause here.
Yeah, correct.
And-
Now, is there a provision in the Constitution which prohibits random drug testing?
Well, it could be inferred.
Okay,
from
there
the
is
intent
none.
of The
I
Constitution
will proceed.
that there's
Is there a
violation
provision in the
this case.
Constitution which prohibits an individual from voluntarily submitting himself to a drug test?
There is unreasonable search
Where?
or equal protection
There is
clause,
none,
just like
Counsel, in the
what is
Constitution.
in
Is
this
there anywhere in the
particular case.
Constitution that this allows an individual from giving his consent to something?
Mr. Speaker,
Yes
we
or
can
no only,
infer
Counsel?
something from
Counsel,
the
yes or no only?
Constitution. We
Counsel,
cannot
this is my
limit
time.
ourselves
Yes or
from the
no?
words
I
of
will
the
proceed.
Constitution.
So when something is voluntary, that means it was not mandatory, right?
It was not. It was
Okay,
voluntary.
okay, I will.
However,
Well,
there is
proceed.
undue influence
So you have
in
to
this
agree with
case.
me that when something is voluntary, there is no intrusion.
There is intrusion in this
Where is
case.
there?
The police
Counsel, I will
officers are
proceed.
wearing
Then you would have to
uniforms
agree
and
with me that
bringing
when an
guns with them when they
individual,
do the
this is my time,
house-to-house.
that when you would have to agree with me that when an individual voluntarily submits himself to a random drug test, there is no intrusion to one's privacy.
But there's a list
Counsel,
that the police
Counsel, that's
follows in
different. That's a
order for
different
them
policy.
to go.
That was the policy last year. So there is no violation in the Constitution, correct?
Mr. Speaker, there is
Counsel,
a violation in
Counsel,
the
yes or no?
Constitution. It is
Okay,
clear.
we'll proceed.
They are violating
So, Counsel, I
the
will
Equal
proceed.
Protection
It is your
Clause, and there's an
contention,
arbitrary
Counsel,
practice
I will
or
proceed.
exercise
Counsel, it
of
is your
police power.
contention that this program by the PNP violates several constitutional rights, correct?
Yes.
Okay. So you are forwarding the notion that it is the PNP which will conduct the drug test, correct?
They are conducting the drug
I will
test in
proceed.
this particular
But isn't it
case.
this policy was the old one implemented last year?
But it is the same
Okay.
one that they
Counsel,
are
that's
trying to
this is
implement
different.
this
is different.
year.
And that the petition was already filed in RTC Branch 100.
We
to
have
stop
RA
this program.
9165, Mr. Speaker.
Counsel, that's
That is
different. It was
already
the
the
House was
exercise of the
testing last year.
legislative
That's
law in
different,
order
Counsel.
to
I will proceed.
enable the police to
I will
act with
proceed,
respect
Counsel.
to drug
I will proceed.
abuse.
I'm pretty sure you are aware that it involved the old House laws.
Okay, Kim, you've got 4 minutes now to rebut Mico and advance your argument on why the PNP's house-to-house drug testing is indeed constitutional.
The constitutionality of a policy should never be tested based on mere speculations. Ladies and gentlemen, your honors, good evening. Tonight, Team CorJesu strongly argues that the PNP's conduct of house-to-house drug testing is constitutional. But before I proceed to my arguments, allow me to debunk first the myths advanced by the affirmative. Let us acknowledge the difference of the old policy last year from the one to be implemented. It will be utterly pointless to discuss the previous approach from which the PNP already desisted and the acts complained of are no longer happening. Now on to my main arguments. The house-to-house drug testing does not violate any constitutional provision as it will be done voluntarily with the full consent and volition of the residents. Your honors, let this point be clear. Based on recent pronouncements, the barangay officials and members of the PNP will go house to house and invite residents to go to the barangay hall for a free drug testing. The invitation will include a clear explanation of what the drug testing is all about. Thereafter, the resident has the free will to say yes or no to such invitation. Yes meaning that they will be tested, no meaning they will not be tested. As simple as that. But what is this drug testing all about?
Your Honors, let us not confuse the drug testing with tukhang, nor equate ano with a possibility. Yes, Your Honor.
Mr. Speaker, you would agree that somebody who says or refuses to the voluntary drug testing will also be given a presumption that he is probably guilty of using drugs if he refuses to comply.
Okay, thank you for the question, Your Honor. Our submission is that no, there is no presumption of guilt, Your Honor, because primarily this is voluntary. If the person, if the resident will say no, then the PNP and the barangay will just proceed to other residents because primarily, again, this is voluntary. Your Honors, let us not confuse the drug testing with tukhang, nor equate a no with the possibility of extrajudicial arrest and killings. On the contrary, the house-to-house drug testing coincides with the state's constitutional mandate to ensure the general welfare of the Filipino people and is in line with the anti-drug initiatives of the barangay, which will then aid in the further examination and rehabilitation of drug users. There is therefore no basis in fact and in law that one's constitutional right to illegal search and seizure and right against self-incrimination are violated, as the individual actually fully consents to the testing. In Caballas versus CA and People, the constitutional immunity against unreasonable searches and seizures is a personal right which may be waived. The consent must be voluntary, unequivocal, specific, and intelligently given. In fact, Your Honors, even last year when it was first implemented, there were no individuals prosecuted for being positive in the drug testing. Neither there was illegal arrest or killing in relation thereto. In short, Your Honors, we should not prejudge the constitutionality of a policy based on whimsical conjectures. On to my second point, even assuming, Your Honors, that there is a potential employment of coercion and intimidation, it does not necessarily translate to the unconstitutionality of a government policy. In People versus Segundo, the court ruled that in the absence of any ill motive on the police, the presumption of regularity in the performance of their duty stands except when there is proof to the contrary. The burden now is on the affirmative side to clearly show that the policemen had abused their power in relation to the drug testing. Your Honor, as of this moment, that burden has never been discharged by the affirmative. Without discharging that burden, we cannot simply invalidate a policy that would actually bring positive impact and rehabilitation to drug users. Secondly, even if there's abuse of power, the solution is not to declare the drug testing unconstitutional, but is actually to prosecute individuals who acted beyond their authority. To recap, the house-to-house drug testing is constitutional because residents will voluntarily do the same, and that even if there's potential employment of coercion and intimidation, it does not mean that the policy is unconstitutional. Thank you.
2 minutes for the cross-examination.
Good evening, Kim.
Okay, good evening.
Kim, the questions I will ask are answerable by yes or no.
Okay.
Republic Act 9165 is a legislative act.
Yes, correct.
Thank you. And it passed sufficiency and completeness test.
Yes, correct.
Very good. House-to-house drug testing is a mere
Counsel,
department
that's
order.
different. There's one, RA 9165
House to
pertains to
house.
mandatory drug testing.
Just
This
right
is
now,
a voluntary
Mr.
drug
Speaker.
testing, Counsel.
This is a
different.
voluntary drug testing based on what? What law?
RA 9165 and the DDB
There's
Memorandum
no law
Regulation number
authorizing
3.
such house-to-house
Counsel,
test.
this is
Let's
pursuant to
proceed with the
DDB
next
Regulation
question,
number
Mr.
3.
Speaker. Next question. In RA 9165, the test is by a forensic
Counsel, you're
chemist
confused. We're talking
in
about the
ADOH
voluntary drug testing here.
accredited lab.
Pursuant to Memorandum number 3 of the DDB, Counsel. That's
Mr.
different.
Speaker, house-to-house testing is conducted in their homes, right?
Yes. Ano? But they
Thus,
will
there
go
is
to
a
the barangay.
violation of
Counsel,
the
they will go to
sanctity of a
barangay. If you have
person's
heard me
house.
earlier, they will go to the
question,
barangay
Mr.
and health
Speaker.
officers
Mr.
will
Speaker,
conduct the drug
please
testing.
respect my
Okay.
time. Next
Proceed.
question. In RA 9165, the result of the test is subject to judicial
Again,
scrutiny.
that's mandatory. It is a voluntary
Just yes
drug
or no,
testing.
Mr. Speaker. It's easy. Just yes or no. Is it a
Okay,
yes
your
or
point.
no? That's a yes. Next question. In house-to-house, the police is the one who scrutinizes the result.
No.
Are you aware of
Health
GMCS?
Counsel, are you aware that health officers are given the chance and given the
Mr. Speaker,
the
Mr.
job
Speaker,
to...
this is my time
Okay,
to
proceed.
ask. Do you know about GMCS? That is
Okay.
the absolute gold standard in order to test whether or not the
And your
person
point?
is whether or not the person is positive for drugs. And the
point
one
is-
that they are using is DIY drug kits, which are not even
Counsel,
proven
if you have
in
heard me
order
earlier,
for
there are
them
no
to
more do-it-yourself drug
accurately-
tests. Health
accurately
professionals
make
are
sure
given the chance
that they
to
are
conduct
indeed
the drug
positive
test,
of
Counsel.
drug
That's
test.
different. You're confused,
Next,
Counsel.
in house-to-house drug testing, the accused is not given a day in court.
That's different,
Thus,
Counsel.
there
That's
is a
different,
violation
Counsel.
of due
Again,
process.
Counsel, I
No
think
further
you're
questions,
confused.
Your Honors.
Let's now hear from the second affirmative speaker, Lester. You've got 4 minutes to argue why it would be beneficial to deem the house-to-house drug testing by the Philippine National Police as unconstitutional.
St. Louis University strongly argues that the PNP's conduct of house-to-house drug testing is unconstitutional and prejudicial because 1, it violates the rights against unreasonable searches and seizures and privacy, and 2, it's a vitiation of consent by undue influence. But before I proceed with my constructives, allow me first to rebut the first negative speaker. The first negative speaker's concept of voluntariness must be misplaced because voluntariness, Your Honors, is a concept or a quality of willingness, consciousness, and intelligence to subject himself to something upon his own will and not by virtue of an order by the policeman knocking at your door asking you to pee in a certain cup, which we don't know if it passed through the process of medical standards. Further, we'd like to argue the purpose of this house-to-house drug testing by the PNP. What is the purpose of house-to-house drug testing by the PNP? The negative said that it's for rehabilitation. Your Honors, it is nowhere in the PNP mandate that they can and they have to rehabilitate drug end users. Now, on to my first point, unreasonable searches and seizures and privacy violations. Article 3, Section 2 of the Constitution guarantees the right of the people to be secure in their persons and houses against unreasonable searches and seizures of any nature and purpose. House-to-house drug testing is clearly a violation of this constitutional guarantee to right of privacy to be searched. Yes, Your Honor.
Is there a specific provision that mandates or empowers the PNP to make a warrantless search and arrest?
That is exactly the point of the affirmative side of St. Louis University, Your Honors, because there's no specific provision that provides the PNP with the power to do warrantless arrest. But let me be corrected, let me be emphasized that there are instances wherein the PNP can do warrantless arrests in cases of flagrante delicto, or whether a person is escapee, or whether or not there is probable cause for a person to commit a violation or a certain crime. Now, Section 4 of Rule 126 of the Rules of Court, Your Honors, requires that a search warrant be based on probable cause and described with particularity. Here, however, the police is in a fishing expedition, which is an indiscriminate means or method of production in the hope of uncovering helpful information. The continued reliance on the order cited by the negative side is tantamount to allowing a general warrant. In Stonehill versus Jokno, the Supreme Court ruled that to uphold the validity of a general warrant is to waive or to wipe out the fundamental right, and that is to subject the sanctity of the privacy of homes and domicile at the whims, caprice, or passion of peace officers. Now, to my second point, Your Honors, vitiation of consent by undue influence. Every man's castle. Yes, Your Honor.
Yes, I would just like to clarify because the first speaker stated that he was against this PNP's conducting the door-to-door drug test because it is not done at random and is based on suspicion. Now, my question to you would be, would you still stand by this theory or position that the door-to-door drug testing is unconstitutional if this will be done door-to-door and not based on any list provided by a barangay leader or group?
Yes, Your Honor, we still stand that it is unconstitutional because it is against the consent of the homeowner. Because even if there is consent, imagine this, Your Honors, a police officer would come knocking at your door. Thank you.
Time now for the cross-examination. You have 2 minutes.
Hello, Counsel.
Good
Yes
evening.
or no answers only. Counsel, we're talking about the constitutionality of the house-to-house drug testing, correct?
Yes.
Okay. Counsel, I believe you have understood every sections of the Bill of Rights. Am I correct?
Yes.
Okay. Now let's talk about one's privilege against self-incrimination. Okay, is that okay with you?
Yes.
Is compulsory testimonial evidence incriminating?
No.
It is.
Testimonial evidence? Yes, it is. Yes,
Okay,
it
next
is.
question. Are purely mechanical acts incriminating? Or not?
Sometimes.
They're not. That's based on the case of People versus Olvis.
No, not all
Is
mechanical
voluntary
acts. Just like
drug
signing
testing?
a signature.
It's my time. Okay.
Go ahead, mea
Is
culpa.
voluntary drug testing a strategy of preventing drug abuse?
That is a strategy, yes.
It is. Okay, thank you. Counsel, are you aware that this voluntary house-to-house drug testing only includes urine samples to be tested?
That's correct.
Okay.
Which is a violation of the zones of
urinating-
privacy of a person.
Please, let me first finish.
Go ahead.
Is urinating a mechanical act?
Well, that's a violation of his
But
privacy.
is it a mechanical act?
That's his private samples. We have to respect
Again,
that.
just yes or no. Is it a mechanical act, Mr. Speaker?
Well, I can't categorically answer that
Yes,
question
it is.
without
Therefore, it is
qualifications.
not incriminating.
Of course not.
Therefore, the voluntary house-to-house drug testing does not incriminate any volunteers, correct?
Because it's not testimonial evidence.
Okay. Counsel, have you heard any instances in the past house-to-house drug test program that one who tested positive was charged to prosecution?
Yes,
None.
in RA
Oh, you're
9165.
speculating. I'm actually
9165.
asking about the victims here, the volunteers, and not the law itself. Okay.
Of course, there's
How
no
about the drug
volunteer
test
here.
results being used in evidence in court? Have you heard
Yes.
any?
Yes.
None. That is so
Yes.
speculative to say, counsel. Exactly, this project is not for destruction but for rehabilitation. Am I correct?
And it's not a mandate
You're
of the
not aware
PNP
of
to
that.
rehabilitate.
Okay, have you read the provisions or are you familiar with BADAC or the Barangay Anti-Drug Abuse Council?
Very well, go ahead.
Have you read the functions of BADAC?
Yes.
Okay, and so I assume that you have read the first function.
Okay, Ada, you've got 4 minutes to rebut Lester and to advance your argument on why it would be beneficial to deem the house-to-house drug tests by the Philippine National Police as constitutional.
Salus populi est prima lex. The welfare of the people is the supreme law. And action, in order to eradicate a social disease, is therefore in pursuit of the general welfare of the people. Good evening, ladies and gentlemen, your honors. Before anything else, please allow me to reaffirm the stance of the negative bench. We are for the protection of human rights, and we are not in favor of any extrajudicial killings or arbitrary arrests. And we believe that a voluntary and free drug test facilitated by the barangay with the aid of the PNP does not violate any provisions of the Constitution. Your honors, onto my rebuttals. The affirmative argues that this act of PNP is prone to abuse. Your honors, it is very speculative to say that there will be abuses because first and foremost, this is a implementation, your honors. And it does not mean that it will be the same with the former drug tests that they have been mentioning. And let me just clear things out, your honors. There is no warrantless arrest, but a pure rehabilitation and not prosecution, your honors. Allow me to proceed with my arguments. First, yes, your honor.
Mr. Speaker, I think it was mentioned earlier that during the mandatory implementation of the DO, there was actually no conviction made. Is that correct? And is it your position that now that it's voluntary, it will be more effective than a mandatory implementation?
Thank you for that question, Your Honor. Yes, Your Honor, you are correct that there was no any conviction that happened in the past implementation of house-to-house drug testing. And that will still be the same this time, Your Honors, because the spirit of this project is for rehabilitation and not prosecution, Your Honors. Let me proceed, Your Honors. First, it is not beneficial to declare the house-to-house drug testing program as unconstitutional because it does not violate the right of people against self-incrimination. Remember that in the case of Ali versus Castro, this privilege only extends to compulsory testimonial self-incrimination and not one that is voluntary. Also, in People versus Malimit, the right against self-incrimination does not apply where the evidence sought to be excluded is not an incriminating statement but an object of evidence. Your Honors, what then is sought to be obtained in this drug test? Only urine samples from the subject individual, ladies and gentlemen. This is purely a mechanical act and no mental, physical, or testimonial compulsion is being given out. As declared by the Supreme Court in People versus Olvis, purely mechanical acts are not incriminatory as the accused does not thereby speak his guilt. The drug test results is also not incriminatory precisely because the aim of this endeavor is not to prosecute. Your Honors, they will only be examined further, and in case of drug testing will generate a positive result for drug use, the individual will only be recommended for rehabilitation, which leads me to my second argument. Your Honors, The barangay and PNP's conduct of drug testing promotes rehabilitation. The main motivation is to help people rehab themselves. It's not to be for them to be listed, not for them to be hang later on. The motive there is for them to be rehabilitated. To rehabilitate, Your Honors, means we are giving the volunteers who turn out to be positive in the drug use a second chance to rebuild their lives without undergoing any inhumane acts that is violative of one's right to life. Hence, reformation and not destruction is the driving force of the program. As my last point, Your Honors, the free and voluntary drug testing eradicates the culture of violence that houses administration's war on drugs. We can even go as far as saying that this voluntary drug test could actually reduce the incidence of extrajudicial killings because it encourages rehabilitation of drug users who are properly identified, unlike that of Tokhang, which resulted to numerous drug-related killings as they were Your Honor.
2 minutes for the cross-examination.
Good evening, Counsel.
Hi, good evening.
It is your contention that if it's not prohibited in the Constitution, that it is allowed?
Yes, of course.
Okay. So, are you saying then that all the provisions in the Constitution are self-executing?
No, I'm not saying that.
So, you just rebutted yourself there. Just as example, is it the case of Biraugo regarding the Philippine Truth Commission? So, you must be aware of that. Okay, let's move forward.
Okay.
Police power is a power vested in the legislature by the Constitution, correct?
Yes.
Very well. In house-to-house drug testing, do you know which branch of the government issued the order?
Yes.
It's
the DDB.
The DDB. And
Yes.
the DDB is under which branch again? The executive, right?
Okay. So your point is, what's your point?
So therefore, Your Honor, since the order came from the executive
Oh, so
branch,
the point,
it is
okay,
not valid.
it comes
because
from the constitutional mandate. Okay.
Okay, I hope you respect my time.
Okay.
Thank you so much.
So
Your
you're
Honor,
actually contradicting
since
yourself.
it was not coming from the legislature that the order should be invalidated.
But
and
all laws
unconstitutional.
enjoys the presumption of constitutionality.
That's what we're saying, and
That's
besides,
what we're
it's
saying.
not
That's
a
what
law.
we're saying, that it's
Okay,
not
let's talk about the
unconstitutional.
purposes of police power. One of its purposes is to promote public safety, correct?
Yes, no contention about
Agustin versus Edu, and it requires lawful subject and lawful means.
that. Yes,
correct?
no contention about
Very
that
good.
again.
Curbing drug prevalence is your lawful subject here,
Yes, of course.
and intruding one's domicile is its lawful means.
They are not intruding one's domicile.
Yes,
Actually,
of course.
there is
They knock
consent.
and they ask the people to go out. Of course,
Maybe
that's
you
not
are talking
intruding
about
domicile.
Tokhang.
Okay,
This
I'll
is
move
not Tokhang.
forward.
This is house-to-house drug
I'll
testing.
move forward. Thank you so
Counsel.
much.
Okay.
Okay.
You're confused.
When they knock at the doors, is there a valid search warrant issued by a competent court?
Well, again, it is from the BADAC, the Barangay Drug Abuse Council. And it is,
Okay.
it depends
But
upon the
please answer
consent.
the question. Please answer, because it's the police who are knocking at your doors.
No, you're wrong. It's the barangay.
Let's now hear from the third affirmative speaker, Diana. You've got 4 minutes to argue the practicability of considering the PNP's house-to-house drug testing practice as unconstitutional.
No one should live in a society that burdens a person to prove his innocence. Before moving on to my arguments, allow me to rebut the points of the negative side. The negative side would like us to believe that just because the Constitution does not prohibit, it means that it already allows. This is wrong, Your Honors, because even if the Constitution does not specifically prohibit, there are safeguards. The Constitution provides for the safeguards in the passing of a law. And worse, Your Honors, the negative side is defending a department order that goes against a Constitution, not even a law, Your Honors, or not even a House bill. Second, Your Honors, they would like us to understand, they would like us to believe on the presumption of the constitutionality of a law. Again, Your Honors, there was no law as a basis. Third, that they would like us to believe is that because they are knocking house to house, that it is already not an intrusion of the privacy. But let me ask them this question, Your Honors. Why does the PNP have to do door to door? Why do they have to knock on every single door when in fact there are other forms of information dissemination? Isn't that the least intrusive means supposedly, such as public announcements or posters in the barangay? Next, Your Honors, moving on to my argument, it disregards the presumption of innocence. Section 14, paragraph 2 of Article 3 of the Constitution states that there is a guaranteed presumption of innocence. This is further buttressed by Article 11, paragraph 1 of UDHR, which says that people can only be convicted when they have been proven guilty according to law at a public trial with all the necessary safeguards to their defenses. However, in this case, Your Honor, every single person is burdened to prove his innocence.
innocence, that you can only prove you are innocent if you pee on a cup and show a negative result. This is not what the Constitution would like to forward. Second argument, Section 36 RA 9165 provides that the only authorized testing centers of drug testing would be government forensic laboratories as well as DOH accredited laboratories. It explicitly states that this is to safeguard the quality of the results. Your Honors would like to say that the PNP, no matter how noble their mission is not equipped with the proper skills and competence required by law. There are two tests, Your Honor, that will validate whether one person is indeed guilty of drug abuse. Number one, the screening test, which will be positive, and the second is the sophisticated and absolutely gold standard of gas chromatography or mass spectrometry, wherein the DOH accreditation is necessary. This mass spectrometry shows whether or not the positive result is indeed because of an illegal drug or other medication taken by the person tested, Your Honor. And we say that only two persons or two institutions can do this: Government Forensic Lab and DOH accredited, not the PNP, Your Honors. Third argument, the cost of the procedure is not commensurate. Imagine 130,000 or just 65,000 people being tested for 150 pesos DIY. That's 9.7 million pesos, and only to what? Rehabilitate? RA 9165 states that you rehabilitate on the first offense. What if you find out that it is already the second offense? You still rehabilitate? It goes against RA 9165. A department order violating a law and the Constitution, that is not what we want. The house-to-house drug testing is like a shoe fitting for all the ladies to identify Cinderella. Only that in this case, when the shoe fits, Your Honor, the person is not brought in a castle to be treated like a royalty. Unfortunately, the person is either listed in the narco list, labeled by the neighbors as addict or sabog, and worse, the person becomes an addition or a target to the more than 12,000 people victims of the drug-related and extrajudicial killings. Therefore, we from St. Louis University are positive that the house-to-house drug testing is unconstitutional. Thank you.
2 minutes for the cross-examination.
Hi, Counsel.
Hi, Counsel.
When we say something is unconstitutional, it finds no basis in the Constitution and
or
in
it
our
violates
laws, right?
a constitutional
All right.
provision.
Have you read Article 2, Section 15 of the Constitution?
I did.
Yes. Then you know that it is a state policy to promote and protect the right to health of people.
Not at the expense of human rights.
Okay. Are you aware that the LGC also mandates that barangays shall adopt measures toward this cause?
They can, but not at the expense of the Constitution.
Okay, I'm sure you have read RA 9165.
Entirely.
Then you know that RA 9165 is also one of the laws created to execute the state policy.
And that is
right
a law, not a department order.
And are you, yes, correct, let's trace it. And are you aware that by virtue of RA 9165, the Dangerous Drugs Board was created to formulate policies and programs for drug prevention and
But their policy formulation is not absolutely constitutional.
Let's trace it. Then are you aware that the
is complete in itself? It does
Council,
not provide for
are you
drug
aware
testing
that the DDB created the Barangay Anti-Drug Abuse Council or the BADAC to further enhance the implementation of the Barangay Drug Clearing Program? Okay,
but did not
so we're
empower
tracing
it to
now.
violate the
We're tracing
human
it.
rights.
Then you know that
There
one
are
of the
other
powers
least intrusive means, Ms.
one of their
Speaker.
powers is to plan, strategize, implement programs on drug prevention
In accordance
and
with the
control
law
in the
and the
barangay level.
Constitution.
Okay, another one of its powers is to coordinate and collaborate with other institutions and units
But not
of the government.
house-to-house drug testing.
Are you aware that free and voluntary drug tests in the barangay halls will primarily be with the assistance of public health officers?
Then why does the PNP have to knock door to door?
Because
if they do not
Council,
want to,
the PNP
if they do
is
not want to
only
give an
for the
undue
purpose of
influence,
security, police visibility, and information dissemination. I
that
think
is
you're
not the
confused.
model that you have
Are
forwarded
you aware
earlier.
that
You have just contradicted
this
yourself,
new
Ms.
approach
Speaker.
on the house-to-house drug testing is actually
There are other least intrusive means,
initiated by
Ms.
the
Speaker,
barangay
such
with
as
the
public
police only
announcement,
aiding.
Glemery, you've got 4 minutes to rebut Diana and advance your argument on why it would be practicable to deem the PNP's house-to-house drug tests as unconstitutional?
Good evening, ladies and gentlemen, Your Honors. As the last speaker of the negative side, allow me to emphasize our main points. First of all, I think the affirmative is confused. We clarify again that this re-implementation is not the same as that conducted last year. Last year, it was the PNP who knocked on people's doors and asked for urine samples. This time, it will be the barangay in partnership with the PNP and other units of the government that will conduct the drug testing in the barangay hall. Let us please understand this difference, because it will be utterly pointless to discuss the previous approach last year from which the PNP already desisted and the acts complained of are no longer happening. Second, Your Honor, the affirmative also say that this approach is prone to abuse, vitiated consent, but they don't have sufficient basis in saying so. We must remember that our officials are afforded the presumption of regularity in the exercise of their functions. Policies and programs of the government also enjoy the presumption of constitutionality, and it is the burden of the affirmative to convince us that this program is unconstitutional based on facts, based on provisions of the Constitution and the laws, and not based on speculation or mere perception or on emotion, Your Honors. Now, we, in the negative, strongly submit that this new approach to house-to-house drug testing is not unconstitutional and is practicable because first, the program actually finds basis in the Constitution and in our laws. Let us trace the authority behind this program. Article 2, Section 15 of the Constitution provides that the state shall protect and promote the right to health of the people. It is the policy of the state to safeguard the well-being of its citizenry from the ill effects of dangerous drugs. The LGC also mandates that barangays shall adopt measures toward this cause, and the DILG called for the revival of the Barangay Anti-Drug Abuse Councils or the BADAC. Now, the Dangerous Drugs Board directed the BADAC to formulate programs to further enhance the implementation of the Barangay Drug Clearing Program, and the BADAC may enlist assistance of any department, office, or agency of the government, including the PNP, public health offices, and the PIDEA. Yes, Your Honor.
Yes, after a 1 or 2 or a million people have been found to be positive for drug use, what do the PNP people intend to do with this? Or the barangay people for that matter?
Thank you, Your Honor. As to the results, it will be for the purpose of further examining them and then later on recommending for rehabilitation. The point is, it is not for prosecution, Your Honor, but for rehabilitation. Now, to continue. Now, yes, Your Honor.
Do you agree that the PNP or the prosecution can also use this information to file a case against those tested positive?
The PNP, the QCPD actually manifested that they will not use this in prosecution, but only for rehabilitation, Your Honor. Now, this re-implementation of the house-to-house drug testing is actually initiated by the barangay, an act which is within its powers and functions, and this time, the PNP will only focus on security, police visibility, and information dissemination in aid of the barangay initiative. So it's quite baffling, Your Honors, how this program can be unconstitutional when clearly it finds basis in the Constitution and in numerous laws and regulations. If at all, what we need to do now is put mechanisms in place to minimize, if not totally eliminate, the likelihood of abuse of power. Hence, the answer is not to invalidate this program based on unconstitutionality, because it is not. Rather, to enact implementing rules and regulations that would safeguard the rights of the residents in the barangay. Your Honors, this is one of the many efforts of the government to reform and correct its highly aggressive approach before.
2 minutes for the cross-examination.
Hi, Clemery. Let us talk about the participation of BADAC.
Yes.
Let us trace where it roots its powers. It is under the local government.
Yes,
And local government units are under the executive branch.
Yes.
Executive branch, therefore, must bow down to the Constitution. So
Yes,
LGUs
yes.
do too.
But they do not
But BADAC
run
also
counter
must.
to the
May I
Constitution.
proceed with the next set of
Okay.
questions? Okay. Let us now talk about the practicability. Do you know that there are 2 tests that must be conducted to make a person positive?
Yes, yes.
Okay,
the
that's a screening
confirmatory
test and the confirmatory
Yes.
test. Now, are you proposing then that even the confirmatory test will be made in the barangay level?
Yes.
Okay.
And with the
May I
assistance
proceed
of
with
the public,
just a
of course,
qualified
it should be
answer.
accredited
This
by
is true
the
or false?
DOH,
A
right?
GCMS or a gas chromatography and mass spectrometry is very cheap. True or false? That's false. It's $69,000, $3 million.
Does that make it
Are we
unconstitutional,
going to its practicability side? Okay, let's talk
still
about the
does that make it
constitutionality.
unconstitutional?
May I proceed with?
Okay.
Okay. When you knock door to door, that means you are going to the privacy of a person.
That is
True
the
or
old
false,
approach.
Miss Speaker?
You're confused, Council. That is
But
the old approach. Now
Miss
they
Speaker,
invite them
may
to
I
the
please-
barangay hall.
And how do you invite them? Your first speaker just stated that you're
Yes,
going to knock
you go
door to door, Miss
and
Speaker.
invite them. And
May
the
I
drug
proceed
testing
with
will
the
be
next
done
question
in the
so that we can
barangay,
proceed?
not in
Miss,
the
I would like to
house.
proceed with the interpolation. Thank you so much. And you are saying that Badak does not have to follow the Constitution just because it's
No, I'm not
has the
saying
mandate.
that. These
But they are
the
intruding.
Badak, the DPP,
May I proceed with the next question
the
as well?
RA 9165.
May-
These are all.
may
I
I
traced the
please?
authority of the.
Exactly, and that
Behind the
authority
program, if
also
you
has to
listen to
bow
me.
down to the Constitution. Anyway, let us move forward now. Is Badak required or empowered to do house to house?
It is
Is
one of
it?
their functions to plan.
Not house to house, but not
it is
house
one
to
of their
house.
functions to
But not
plan
house to
and-
house. Miss Speaker, no
That
further
is
questions.
included in their powers and functions.
Let's now hear what our judges have to say about our debaters. Attorney Tagian, how did the affirmative side, St. Louis University, do?
Yes, first of all, I'd like to congratulate both teams for a very spectacular performance. As for the affirmative side, I commend their arguments are very concise and they have eloquently delivered their positions and for the audience to appreciate it. So it was a solid performance all in all. Thank you.
And Attorney Aniag, how did the negative side CorJesu College do?
I would just like to congratulate first both teams for giving a very healthy discourse on the topic tonight. The research, the arguments that the negative side presented were well researched, and then it's well argued. And I enjoyed particularly the opening statement of the team captain that he was able to set the tone of the negative side. So overall, they did excellent work.
And now let's hear from our chief adjudicator, Judge Marie Claire Victoria Mabuta Sordan. Your Honor, who did the judges pick for Best Speaker?
Well, okay, before I make the announcement, I'd like to congratulate both groups for well-researched and well-discussed arguments. And I imagine the audience will have a lot to think of. And, you know, they'll have a lot of thinking to do to decide whether or not they should consider this act unconstitutional or constitutional. Anyway, three judges, the two well-distinguished judges beside me, we have unanimously voted as Best Speaker for this round, Ms. Dianalyn Santos.
Her Cinderella comparison worked out to her advantage. Now, Your Honor, the school that won this round.
All right, for the school that won this round, again, our decision was unanimous. We all went for the affirmative side, St. Louis University. Congratulations.
A big congratulations to the affirmative side, St. Louis University, for winning the first slot in the finals. Next week, San Beda University and the University of the Philippines will face off in the second semifinal round. I'm Maiki Oreta. Thank you for watching.